Appeals of Tennessee is now in session.
Good afternoon and welcome to the afternoon session of the Tennessee Court of Appeals. First of all, I want to tell both of you how much we appreciate you participating with us via oral argument by way of Zoom. And it's not necessarily the way we'd like to do it, but it's the way we have to do it at this point in time. We will, of course, utilize all the same protocol and procedure as if we were in court today. By that, I mean each side gets 15 minutes to make its oral argument. If you're the appellant and you've reserved rebuttal time with Mr. Hibner before, then you'll receive that time as well. If in fact we have any technological problems, everybody just remain calm. We'll work through that. We'll make sure that nobody's prejudiced by that. We certainly don't expect any problems, but if anything occurs, we'll take care of that. Before we get started, let me introduce our panel for today. Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
You may call the case then.
F&M Bank versus George Raymond Fleming, Jr.
All right, we will hear from the appellant.
Thank you, Your Honors. My name is Thomas Bloom. I represent the appellant, in this case, George Fleming. This is an appeal from a summary judgment in favor of F&M Bank against my client. F&M Bank had foreclosed on property which secured a note from Mr. Fleming and sought a deficiency judgment. Now, the linchpin, I believe, issue in this case is whether Mr. Fleming waived the affirmative defense of inadequacy of foreclosure sales price that was received at auction. And from this foundation, the issue becomes whether Mr. Fleming raised a disputed fact to defeat the summary judgment, or whether he should have been granted a continuance to conduct discovery on the issue. Now, the complaint, this is an old case. The complaint was filed in late 2017. The note was $1.587 million. It was secured by 15 parcels of real estate and about 6,250 shares of stock in F&M. The deficiency judgment sought in the complaint was $212,857. Now, Mr. Fleming's attorney filed a notice of appearance in November of 2017. He contacted the bank requesting documentation as to the deficiency, how it was arrived at and whatnot, and he received only the copy of the note. Thereafter, about a week later, the bank filed a motion for default judgment. Hearing was set for January 11th of 2018. A day before it was to be heard, Mr. Fleming's attorney filed a motion for a more definite statement. He wanted to know how the application of the proceeds were handled. He was unable to determine, he stated, what affirmative defenses he might raise. He didn't want to do a shotgun approach. He requested documentation as to the nature and circumstance of the foreclosure sale. Now, it's really too bad he had not called this a request for production of documents, which he did not. However, it certainly gave notice to the bank about what the defenses could likely be. The hearing on the default judgment was held in January. The judge denied the default judgment, ordered Mr. Fleming's attorney to file an answer within 10 days. Now, they also addressed Mr. Fleming's motion for a more definite statement. And there was some ambiguity on this question of what the judge actually ordered from the bench. It was not put into a written order. And now, granted, we can argue both ways. I say it's ambiguous. I don't think it's clear. I think it's clearly not clear. And certainly in Mr. Fleming's attorney's mind, he was allowed to reserve his affirmative defenses pending discovery. In fact, that's what his answer actually stated. He specifically reserved all affirmative defenses that would be during discovery. So regardless of what might have been intended, that's how it was understood. And I think it's fair. That's a fair interpretation. Now, after that 2 years passed, a full 2 years, the bank did nothing. There's no scheduling order. There's no request for admissions or whatnot. And a show cause order was issued for the bank to do something or fail or have it dismissed. They came up with a motion for summary judgment. And they changed the deficiency from $212,000 down to about $87,000 without really an explanation. Now, Mr. Fleming's attorney filed a response. He wanted to continue, wanted to have more time for discovery. The attorney, his affidavit complied with Tennessee Rule of Civil Procedure 5607, in that he said he had not conducted discovery to that point because it didn't appear that the bank was prosecuting. They had basically done nothing for 2 years. Why kick a sleeping bear? He said he needed discovery as to the manner of the sale and the prices paid, and that information was exclusively in with the bank. He also filed a response to the motion for summary judgment, and in this motion, he put in an affidavit from the assessor of property in Montgomery County. Now, the tax appraisal value of all the parcels of properties was $1.7 million. Mr. Fleming's attorney had no idea how the bank had purchased 10 of the 14 properties and had sold the shares of stock. They bought those 10 properties in aggregate. He had no idea of what the various prices were, whether it was below fair market value or not, or below the tax appraisal value or not. He did know that three of the properties were sold to an individual by separate deeds, 3 different deeds. And he did know the prices of those, and those were between 40 and 50% lower than the tax appraised value. I don't know whether the court can or would take judicial notice, but from my experience, tax appraisal values are far less than fair market value in any event. But 3 of the 14 properties certainly were 40 to 50% below fair market value, which would raise a disputed fact. Now, the bank just replied basically saying he had waived his affirmative defenses. He had 2 years to conduct discovery. He hadn't done it. He also didn't do it during the 3 months that the summary judgment motion was pending. The court basically just agreed. That was you waived your affirmative defense, and you hadn't conducted discovery. Now, so the waiver issue, the bank cites the branch bank and trust versus Hill case, which is true. It basically says inadequacy of foreclosure sales price is an affirmative defense, and failure to plead an affirmative defense is a waiver. And the purpose, of course, is to prevent any sort of ambush at trial. Now, it's interesting to note that in the branch banking case, the affirmative defense was raised at trial during cross-examination. So, of course, that was an ambush. I believe, based upon my readings of the cases, the exceptions and the caveats to that general rule almost swallow that general rule. I cited 3 Supreme Court cases in my brief, as well as a Simmons case, Court of Appeals case, and basically, the failure to raise affirmative defense is not always a waiver. The judge has wide latitude to allow amendment of an answer. The issue is really and solely, did the defendant have sufficient notice prior to trial? In this case, it's clear from the very first phone call with the notice of appearance up into the summary motion for more definite statement, up to the responses to the summary judgment motion. Clearly, the bank had noticed that this was going to be an issue. I think it's an abuse of discretion for the court not to allow a continuance to the discovery. I'm sorry, not to allow the affirmative defense of inadequacy of foreclosure sale price to be allowed under these circumstances.
Was a motion filed to amend the answer to include the affirmative defense?
It was not. It was not. And I anticipated that question. I would rely on the principle of having the pleadings conform to the proof. I don't think on a technical thing like that, he should be thrown out, not having a trial on the merits, especially when he's.
I mean, what was the proof other than you've got tax appraisals that may or may not be considered by the court? So what was the proof that you want the evidence to conform to?
Well, this is the thing. Regardless of whether he did not file a motion to amend, however, clearly that is what was the gist of the whole thing. I mean, the proof is that at least 3 of the 4 properties were sold well below the tax appraised value, which is below generally fair market value. I mean, that is the proof. I mean, he submitted something, you know, and again, even if he hadn't submitted that, but he did, even if he hadn't, I think it would have been abuse of discretion not to allow him to amend his complaint going forward.
But what was in front of the court for the court to react to? I mean, the court apparently ruled early on that he had waived that defense if there was something that new that developed, something that came to the attention of the parties, then it was the responsibility of the parties to bring it back before the court and say, didn't know about this, or we intended to do this. It's not the responsibility of the court to do something without some request before it, is it?
The court had not at that point held that he had waived that affirmative defense. He brought up, it's the same thing as bringing up in the banking branch case, bringing up this affirmative defense at cross-examination. You know, he brought up this affirmative defense. He might not have filed a motion to amend his answer at that point, but he brought up this affirmative defense clearly at the summary judgment motion. And it was after that the court found that he waived it. The court did not say, again, that order is ambiguous. You know, I don't think there's any way you can say it's a clear order through no one's fault. And I think he should have gotten the continuance. Continuance is all you have to give a good reason of why you want a continuance. His good reason was 2 years of nothing happening by the bank. There's no reason to kick a sleeping dog. I'm going to my rebuttal time very briefly. So I believe that continuance should have been granted. And lastly, if we get over this waiver issue, which I don't think should be a big obstacle, I don't see it, Judge Stafford, as a big obstacle. I think it's as clear as mud. That's it should that was an abuse of discretion. But even just bringing up an affidavit from the tax appraiser showing that 3 of the 14 properties was sold 40 to 50% below the tax appraised value, I believe that in and of itself should have defeated the summary judgment motion. However, what we're asking, I mean, we'd love to get that, but failing in that, we would just like it remanded so that he can amend his answer and he can conduct his discovery within a reasonable time, so this case can be tried on its merits. Thank you.
Thank you. Hear from the appellate.
Good afternoon. I'm Mary Cheadle on behalf of F&M Bank. It is our position that the trial court ruled correctly and found in favor of the bank on the motion for summary judgment. The defense of inadequacy of foreclosure sales price was waived. There was a length of period of time from when the lawsuit was filed and an answer was then filed in response. In the meantime, a motion for default judgment was filed. At the hearing on that motion for default judgment, the trial court denied the motion for default, told Mr. Fleming to file an answer within 10 days, and suggested in that hearing that he assert all possible affirmative defenses. None were done in the answer. It was a general denial. At that hearing also, it was quite clear.
When the answer was filed, did he reserve the right to amend his answer and assert additional defenses rather?
There was a reservation to be able to reserve affirmative defenses after completion of discovery. There was no discovery that was done in this case.
Is that why the trial court ruled that the affirmative defense of inadequacy was not allowed?
I think it was based on 2 reasons. The first reason being that it was not asserted in the answer. And second, I believe it was because there was a period of 2 years in between, or over 2 years in between, when the lawsuit was filed and the motion for summary judgment was filed, and no discovery had been done. Also, there was a time period of 3 months in between when the motion for summary judgment was filed and the hearing was heard on it. There was also a request by Mr. Fleming to continue that hearing. So there was more time in there allowed for Mr. Fleming to do what he needed to be done in between the filing of the motion for summary judgment and the hearing. So during that 3-month period, there was also no discovery done. So I think that those two things are what the trial court took into consideration when it determined that that defense was waived. Also, it appears that when
was the defense attempted to be raised for the first time?
It was first raised when Mr. Fleming filed his response to the motion for summary judgment. And also at the same time, he filed a motion to continue under Rule 56.07 to continue to be able to have more time to go into the possibility of this defense. And that affidavit in support of that motion to continue, I do not think was in compliance with what the rule allows. It only set out, well, I have this possible defense. These are the substantive merits of the case. And what that affidavit requires is that the individual that wants a continuance to be able to do discovery or collect more affidavits in support of their position on the motion for summary judgment is to show why they have not been able to obtain that documentation or the necessary information. And none of that was in the affidavit because nothing had been done to try to obtain that information through discovery. There had been early on, after the motion for default was filed, counsel for Mr. Fleming contacted me and asked for the promissory note. There was no other request for information. We were not aware that this would be a potential defense. The motion for a more definite statement that was filed early on was actually just listing information about an accounting and did not specifically state that this would be an affirmative defense of inaccuracy of foreclosures. He actually struck that motion for a more definite statement. It did not go any further. The court also found on the motion for summary judgment that a statement of facts had been done in compliance with 56.03, to which there was no response to. That statement of facts sets out that there was a loan that was applied for, money was borrowed, Mr. Fleming failed to pay its promise, and the stated amount that was owed, and none of that was disputed. And it's our position that also the trial court relied upon that because that is the standard of a Rule 56 motion for summary judgment. I don't think at any point the bank was aware that this would be a potential defense to the lawsuit until almost nearly 3 years after the lawsuit was filed. And it just came down to Mr. Fleming did not do anything to try to further that defense, which is an affirmative defense. And under TCA 35-5118, the bank had the presumption that the properties were sold for the fair market value. And the burden was on Mr. Fleming if he wanted to show that that was not the case. And he did not meet that burden by simply filing an affidavit of the tax assessor that lists values of property. It's not enough to put before the court on a motion for summary judgment. It wouldn't be enough to be put forth before the court at a hearing on a trial. He just did not take on that burden of exploring that defense, and it was not properly before the court. So it's the bank's position that the trial court properly granted the motion for summary judgment, properly denied the motion to continue, and granted judgment in favor of the bank.
All right. Anything else?
No, Your Honor.
All right. We will hear from the appellant in rebuttal then.
I would just strenuously disagree that the bank didn't have notice really from day one that the manner in which these properties were sold would be an issue and would likely be an affirmative defense based on the information that they had not provided. In that motion for definite statement, it's on page 5. One of the things that Mr. Fleming's attorney is saying is that my concern is the affirmative defenses have to be raised at the responsive pleading. I don't want to shotgun affirmative defenses. I mean, if I can reserve this for discovery, but obviously there may be some defenses available because of the large differences between the amount of the note and what they're claiming owed, and I don't know how to get there. I don't even know if it's a deficiency. He's saying he doesn't know. I don't know who may have bought these properties, how the funds were applied, or anything. So notice is there. In a perfect world,
motion stricken.
No, it was stricken mainly because it was heard. It was heard at this default judgment.
It struck and be heard too.
Well, I mean, Judge Stafford, I understand, these technical arguments or technical questions that you're asking. I understand them, but I also know that we live in a practical world, in the sense that if you stand up before a judge and there's a motion pending and that's determined, it's discussed and you understand what's going on, you believe that, okay, I can reserve my affirmative defenses pending discovery. I'm going to put that in my answer. I'm going to do something with this motion that's pending in a hearing date. I'm going to strike it. So, I mean, I understand what you're saying, and I respect what you're saying totally, but I don't think that's the real crux of the matter. I believe that
I think it's obviously it's all important. It's the procedure that was utilized in this case. I'm just trying to understand what was going on. Yeah, and I don't really need a lecture. I was a trial judge for 15 years, so I think I understand the procedure in the trial court. So go ahead with your argument.
Oh, I didn't. If I caused any offense, I apologize. It certainly was not meant. It was not meant as any sort of a lecture.
Mr. Bloom, let me ask you,
please.
In Mr. Fleming's answer, did he allege any procedural irregularity in connection with the sale? Because the inadequacy of the price doesn't really matter. That doesn't give you a victory saying, oh, it's, I should have gotten more. We already know that. You've got to allege some irregularity in regard to the sale that has nothing to do with price. Was that alleged in the answer?
I believe that he did bring up the idea of bad faith. He brought up the lack of good faith in his answer. I know that's in the record. I know it was brought up. I mean, there's 10 properties were sold to the subsidiary of the bank itself, which is not in and of itself, certainly not bad faith. I mean, that happens. But yes, he did bring up the idea of the sale not being in good faith.
Why didn't he seek discovery during that 3-month period from the time the motion for summary judgment was filed and the hearing date?
I wish I had an answer for that, Judge. I really don't. I mean, obviously, I was not the trial counsel. I'm not sure why he did not do that.
Yeah. Like you, I understand not doing anything for that 2-year period. If somebody's suing you and you don't have any good defense, I mean, why wake them up? Just do nothing and wait. But once they file that motion for summary judgment, then don't you have to do something?
Yeah, I think all that he did do was that he did get the notice of foreclosure from the public records, and again, they got the affidavit from the tax appraiser. But that's all that he did.
Right, let me ask you one other thing.
I would like to think I would have done things differently, but
when he requested a continuance for discovery, did he mention at all the fact that the complaint, the amount that they were seeking, went from $200,000 to $87,000?
Yes, he did. And he mentioned that there was no explanation for that. And I tell you, I wondered about that in writing the brief. And what I think probably happened, not that it's important. I think there were 15 parcels of land. The bank bought 14 and the bank bought 10 and someone else bought 3. And the 3 were the ones where it's clearly, inadequate consideration, I think. I bet that there was one parcel of land still out there, and it could very well be that the bank sold that. Because when I was writing the brief, there seemed to be a missing one parcel of land out there. So, but he did bring that up. He said there's no explanation of how we got from $212,000 to $87,000. So
I have one final question, and that's this. Do you agree that there was no response filed to the motion for summary judgment other than a request to continue?
Yes. And with the clarification, that's all true. Everything that they said is true. You know, so deemed admitted. You know,
Okay.
and Judge Stafford, let me just say this again, please. I don't want to get on your wrong side. If I came across as too strident or lecturing, that's not me. You know, it's not me, and I apologize very much if I offended you in any way
No
whatsoever.
problem. No problem. You don't need to apologize, but I accept your apology, but there's no issue there whatsoever. All right, counsel, we appreciate your argument. We will take this matter under advisement, and we will endeavor to get you an opinion as quickly as possible. We again appreciate you participating by Zoom. Ms. Tibner, anything further?
No, Your Honor.
You may recess until the call of the next case.
This honorable court is now in recess until 3 p.m.